Thanks, everyone. The first item on our agenda is approval of board minutes from the November board meeting. If there are no additions or corrections, I'd entertain a motion and second to approve.
Moved. Second.
Second.
Okay, all those in favor say aye.
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 Opposed, same sign. All right, minutes are approved. We have one item on our agenda today related to the technical plan, and it's going to be a review of the research on 457 deferred compensation plans. So I'll turn it over to Mr. Dean Mead.
Thank you, Mr. Chairman. Hello, everybody. Since this is the only item on the board, I have 4 hours, right?
Right.
Okay. I basically just read the research memorandum to the board. I will not belabor this, but I do want to, touch on the basics of what we did and why, and then open it up to your questions. Statement 32 itself actually superseded a prior statement, Statement 2, on deferred compensation plans, and was prompted by a change in the Internal Revenue Code that required that Section 457 plans going forward be held in trust for the exclusive benefit of the employees in the plan, which changed the way that those assets were viewed. They were no longer viewed then as assets of the government, which is more or less the way they were being reported before. So what Statement 32 did was require that 457 plans apply the valuation provisions of Statement 31 to specific investments that are identified in Statement 31. And that provision was reviewed already as part of the project that resulted in Statement 72 on fair value. The other main provision of Statement 32 was a requirement that 457 plans that met the criteria in NCGA Statement 1 for fiduciary funds be reported in the fiduciary fund financial statements. That provision has also already been reviewed as a part of the project that led to Statement 84 on fiduciary activities, which in fact supersedes that provision. So this is consequently a narrower re-examination than is typical for our pre-agenda research. We focused primarily on a statement made by the board and the basis for conclusions to Statement 32, that because there were no required employer contributions to 457 plans, they were more akin to tax-deferred employee savings plans. And although that's non-authoritative, it was the basis for a question and answer in our implementation guidance related to whether a government that makes contributions to a Section 457 plan should report that plan under Statement 68 on pensions. And the answer was that based on that board position, that because 457 plans are not considered to be pension plans for financial reporting purposes, they should not be reported under Statement 68. The research consisted of 3 phases: a literature review, telephone interviews, and then lastly online surveys. The literature review was very brief because 457 plans are unique to the U.S., so the only possible standards would be those set by U.S. standard setters, and of those, the FASB has guidance on deferred compensation in general, but not specifically about 457 plans. And other than that, our guidance is really the only guidance that exists. The purpose of the telephone interviews was for us to get up to speed on the present 457 plan environment so that we could then develop broad-based surveys to get significant feedback on the nature of 457 plans today versus where they were in, excuse me, back when Statement 32 was issued. We conducted 12 interviews with 9 auditors, 5 preparers, and 2 officials from 457 plans, all of whom were very familiar with 457 plans. And those interview results led directly to the surveys, and the things that we heard in those interviews were in fact confirmed by the surveys, and I'll tell you the results of that in a moment. We conducted 3 separate surveys, one each for preparers from state and local governments that sponsor 457 plans or whose employees participate in a 457 plan. We call that the government survey. Officials from 457 plans or retirement systems that administer them. That was the plan survey. And then auditors with experience auditing the financial statements of 457 plans or employers that sponsor plans or have employees that participate in them. The surveys were very brief, unlike most of our surveys, very simple to respond to, and basically pose questions regarding whether there were employer contributions to the plans, how the amount of benefit that the plan members receive is determined, whether the employer retains any risk with respect to gains and losses on the plan's investments, whether the government appoints a majority of the board of the 457 plan, which we thought would be helpful in assessing how these plans are structured in relationship to the primary government, and in the case of that particular question, whether they were structured as component units. And then lastly, whether the government reports the 457 plan as a fiduciary fund, which we expect will be helpful in understanding how any proposed changes, if this becomes a project, to existing guidance might interact with the application of Statement 84. We received 146 usable responses to the government survey, 32 to the plan survey, and 40 to the auditor survey, which I think is a pretty nice response to a fairly narrow topic. The findings of the research, and as I said, these are points that came up during the telephone interviews and were confirmed in the broader-based surveys. It's clear that some Section 457 plans are similar in structure, characteristics, and operation to arrangements that are currently classified as pension plans in GASB standards. Those plans appear to be like defined contribution pension plans and do not have features of defined benefit pension plans. Most notably, a substantial number of the Section 457 plans that were represented by the people who responded to the surveys now receive employer contributions. About 1/5 of the respondents to the government survey said that employers make contributions to their 457 plans. Employers make contributions to over 37% of the Section 457 plans that responded to the survey. And almost 1/3 of the respondents to the auditor survey are aware of Section 457 plans that receive employer contributions. And because they tend to be exposed to more than one plan or more than one employer who participates in a 457 plan, that point of view probably represents an even larger number of plans. At the same time, virtually every respondent to the 3 surveys stated that the amount of the benefits that members of the Section 457 plan receive is dependent solely on contributions to the plan and earnings on those contributions. And virtually everyone who responded to all 3 surveys said that employers do not retain any risk associated with gains or losses on those contributions. The handful of responses that were counter to that, based upon the responses to follow-up questions that we posed in the surveys, we're fairly certain they were confused or misunderstood the question, and so I'd hazard to say that it was unanimous in the responses from the survey respondents that there weren't any defined benefit like characteristics to any of these plans. The bottom line, I think, to this research is that there is a notable number of Section 457 plans that appear to meet our definition of a pension plan, in particular a defined contribution plan, but most of them remain similar in nature to the tax-deferred employee savings plans that the board viewed them as at the time that it issued Statement 32. So with that, I would welcome any questions that you have.
Questions or comments from board members?
Dean, did you get any sense as to whether the in the circumstances where there were employer contributions, that those contributions were discretionary as to a level or whether or not a contribution was made, or whether they were mandatory?
We didn't specifically ask that question, Jim, but I know that there are instances in which the contributions to the 457 plans are a stated part of the employee compensation. The employee unions, for instance, have negotiated with the government to make that a part of the official compensation package of the employees. So it may be the case that some of them are also done on a voluntary basis, but it's clear that some of them, are as formal a form of compensation as pensions and OPEB.
Dean, I had a question. I don't know, Jim, were you done there? Jim, or are you okay with that? You have anything more? All right, I'll go ahead. Dean, on table 6, I was interested that so many of the state plans, or more of the state plans, tend to report as fiduciary funds, but other forms of government don't. Do you have any thought about why that might be happening?
Sorry, what?
Page 26.
Page 26. Sorry, I should have the whole document memorized. I think it's similar to what you'd see for reporting any kind of retirement plan. That they're much more common among states than they are among sub-state level governments, and I think that's that's the sum total of it. I think a lot of pension plans. It's not unusual for a Section 457 plan to be provided at the state level and allow participation by local governments.
Okay. Thank you.
Hey, Dean, this is Jeff. Do you have any sense? I know you said limited discussion of other standard setters, but in the FASB world, do we know how? Because do non-for-profits have these 457s as well?
They do.
And do we have any idea about is their reporting or non-reporting similar to what we experience on our side? Do you have any sense of that?
Well, they don't have any guidance that says these aren't pension plans. So they are evaluated using the same criteria that all retirement plans are use in the FASB sphere, which is basically 4 criteria that in topic 715 that define what constitutes a retirement plan.
Yeah, and so it would be that item C there, the deferred compensation contract, that these things would fall under.
Yes.
Yeah. And Jeff, the other issue is that they, of course, would not go through the consideration of including a pension plan in their financial reporting entity.
Right.
That's an issue that we have to deal with as state don't.
Jeff, for clarification purposes, the only entities under the FASB that are even eligible to have 457 plans are not-for-profit organizations.
Mm-hmm. Mm-hmm.
And the circumstances in which a not-for-profit is permitted to have a 457 are fairly limited, and they tend to go to additional compensation for key executives.
Mm-hmm.
Agreed.
Yeah.
It's required.
Yeah, in fact, why don't you just go ahead and say it, Becca?
Yeah, so for non-governmental 457 plans, they can only be used to compensate the most highly paid employees. It's a top hat plan, or considered a top hat plan. And they have different reporting requirements under the IRS, or different trust requirements.
I should have mentioned at the beginning that Becca and Ellie are here, and they did all the real work on this, and under the direction of Emily, who is on leave right now. So I'm playing the role of consultant Emily Paul.
Dean, I have a question. Several of the commentators indicated that, or implied at least, that they do not report the 457 plan in their CAFR at all. How can that be? What's the rationale for that?
Why? Because I think that most of the people who responded don't sponsor 457 plans. That
One comment, for example, is we really struggled with whether or not to report our 457 plan in our CAFR. The guidance didn't seem very clear. It was a county.
Yeah, I think, if I'm not mistaken, I think that comment probably relates to reporting it as an employer as opposed to reporting the plan. That's how I understood that particular comment. I should also mention that of the comments that are in here that we got in response to that last open-ended question about whether they had anything else to say, I'd say the only comments we really got were either people who were clarifying a previous answer or who were taking that as an opportunity to tell them they didn't want to report these as pensions.
Yeah, but there would be no basis for not including it at all in the CAFR under our extant standards. Is that right?
There's no requirement whatsoever to report them either way in our existing. In fact, quite the opposite. With that implementation guidance, that it says they're, for financial reporting purposes, they're not pension plans, and therefore, shouldn't be reported, by employers under Statement 68.
No, but they have to be reported somewhere. They have to be reported somewhere in the CAFR.
Not necessarily.
No.
For example, if it's strictly employee contributions and the plan is administered by a third party, and until 84 came along, there really wasn't a basis for making an assessment. So a lot of people have treated these as being outside the reporting.
So they'd be reported just as an independent entity under no government's in no government's CAFR.
Well, there may be situations. Again, though, we have Statement 84 now that should be applied to those.
Right, that should be right. Obviously, right. But I take it many of these comments did not reflect the implementation of 84.
Correct. I think they view them well. They're not pension plans, and and I have no involvement. Although there's a question because there really wasn't any guidance as far as what involvement triggers a reporting as a fiduciary activity, and therefore they concluded that it shouldn't be included as a fiduciary activity.
So wouldn't be included at all then? Not as a,
right.
That's what they concluded, right?
Yeah, and Michael, if you look, I was noticing the same thing at the bottom, the comment that goes on the bottom of 31, top of 32, the second sentence of that comment, where the person says a number of entities don't report it because in their mind it's only an employee contribution, does not have any administrative responsibility, and they contract with a third party to take care of the plan, therefore they consider it not theirs, basically.
Yeah.
Right.
It's fine.
I had one other question on page 27. Major support of education for me on how these plans work, although I thought I had some considerable experience, but I haven't seen this curveball here. A majority of other respondents, however, stated that the sponsoring government does not appoint a majority of the plan's board. And you give some percentages about that. Who is on the board then if it's not members of the sponsoring government? Do we know? Have any clue? Or is there basically no real board?
No board.
That's the case, and in some of the comments, that aren't included here because they weren't really making separate points, but there were a number of survey respondents who mentioned in their additional comments that they don't have a board at all. And there are some that are contracting, with a private firm, effectively to provide these options to their employees. and there's, so there's no governing body for that. It's a, it's just a company that they're, contracting with to provide benefits.
Yeah, they just view it as a mechanism to allow the employees to put their money elsewhere, but don't really see it as a functioning board. It's just a benefit offered by the government that allows them to participate at their choice.
Mm-hmm.
Okay.
And on that, so on the chart on page 28, so because the plans seem to indicate or respond that the sponsoring government does appoint the board. So 78% said yes, sponsoring government appoints, but that's way above. How do we interpret that table? Because I notice states have a high percentage of yeses. So are the plans that we're talking to sort of state level plans, and that's why I should consider that 78 more like the 60 rather than the 26.7?
Yes. If you're hearing from the plans themselves, you're already talking about a situation in which, it's government sponsored, that it has a government administrative apparatus around it, because they are either responding from a plan or from a retirement system. And so you're much more likely to see it from them. Also, obviously with the states for the same reason, and also the state auditors, because they're going to be primarily familiar with their own state's plans.
Yeah.
Generally more formalized.
And I had one other question, just on page 13, just in this, we had this view that 457 plans didn't have employer contributions, and then Dean, in the discussion on page 13, we talk about this 2001 Act, which sort of changed the way contributions could be accounted for, say there, resulting in subsequent increases in the prevalence and amount of employer contributions. So this legislative change, which was post 32, do we sort of have a sense that that really might have changed the dynamic in terms of the amount of employers contributing to these 457 plans?
Yeah, I think there are other things going on during that period, but I think it's previous to that. If contributions were going to other plans in the code, it left very little room for any additional contributions to be made to a 457 plan and have them still be tax deferred. And by removing that dollar for dollar offset, they essentially made available the entire limit, in terms of the contributions that could be made to the plan. And that, I think, created the opportunity for employees to request that employers make contributions to those plans. They could have asked before, but there would have been very little opportunity to do so if the employees were already making contributions of their own, and if they were participating in other kinds of plans in that part of the Internal Revenue Code.
Yeah, so it seems likely now that they have more room for contributions, that they could now more easily contribute to the 457 plan.
Agreed.
Right. And you probably saw an increase in participation by employees because in many cases, the employer will match up to a certain percentage that the employee contributes. So if you didn't contribute, you were effectively giving up a benefit that you would have otherwise gotten. So it encouraged more participation by the employees.
And I noticed, too, that there's at least some plans, it was mentioned on page 16, that the government will contribute to the 401A plan if you participate in the 457 plan. And not being an expert in this, I'm wondering, why would the government do that?
I think from the government's perspective, it's six of one, half of the other, Jeff. They're matching the contribution, but already have a structure in place for making contributions to a 401A plan.
Yeah, but it seems to be that they'd be incentivizing participation in the 457 by doing a match into the 401A, right? Rather than just saying, hey, we'll do a match into the 401A of your contributions to the 401A. They'll do a match in the 401A of your, instead of the 457. Right? So I guess that's something else for us to think about, right? In terms of when we think about 457s get contributions, well, the contribution may not go into the 457, it may go someplace else.
True, but
That wouldn't be considered a 457 contribution, but in fact, it's keyed off of what the employee contributes to the 457.
yes, but not a part of the survey respondents who indicated the contributions would be made to the 457 plan. That's really what they were talking about for the most part. That these were actual contributions to the 457 plan, not contributions related to the 457 plan.
Right. Okay, thank you.
Other comments or questions from the board?
I realized that we weren't looking at 403B plans, 403B annuities, etc. But I did see some mention of them in there in some instances. Of course, part of it is because of those are still connected to the overall contribution limitations, whereas a 457 is not under the revenue code. But did you get any sense at all as to whether or not there was any linkage between for governments that offered a 457 plan and offering of 403B?
Not that I'm aware of, no. It doesn't mean it doesn't exist,
Yes,
but
but-
wasn't something that came through in our research. We weren't specifically asking about it either, though, so.
Okay. I guess I'm just going to point this out. If we move forward in this area, I know from personal experience that 403Bs are now under much greater scrutiny. But 403Bs now allow for an employer contribution, where when they were originally conceived, there were nothing more than a salary reduction agreement that the employee entered into.
Yep.
But now you can have an employer contribution to it in addition to the salary reduction by the employee, as long as you don't exceed the overall employer contribution limits to all of the affected plans, with 457 being outside of that limit. And so I know we've not ever looked specifically at 403Bs, but if we're going to be going into this area, and one of the major changes with the 457s now is the at least allowability of an employer contribution, I wonder if we need to do some consideration of 403B annuities also, especially given that they're receiving a lot more scrutiny by the Internal Revenue Service, federal government, and in some instances have an audit requirement attached to them now under ERISA, which I realize doesn't cover governments, but there is a requirement for governments too. I know this is a big deal for a number of school districts in various states.
Jim, do you think that there's a reporting problem there? I mean, with 457 plans, we have the specific issue where we've said don't report them. Is there, we haven't said anything like that about any other plans, which ought to be judged under the pension plan definition in 67 and 68, as well as the fiduciary activity definition in 84.
I almost guarantee you that most governments aren't looking at that. I'm not disagreeing with you, but given that historically these weren't pension plans, they were a deferred compensation type situation, and it was an individual agreement entered into by each employee, and then the employee invested. The money was invested in options that the employer chose.
Well, Jim, that may be something that we could potentially look at as part of a Q&A. But the the thing is, we haven't looked at those, and this is you'll see the prospectus in a couple of days related to this project, but it's a very narrowly scoped project on a relatively fast track, and if we hold up, as you know, there's a lot of different types of plans like this out there, and we probably have to get a pretty good handle on that before we move forward, which would slow down, as Dean said, what we're trying to do here, and that is fix a potential problem. The board's ultimately going to have to determine, does this meet the criteria for a pension plan, in your opinion? If it doesn't, then we don't do anything. But if you do agree, then we can make a quick fix to authoritative literature, and then follow up with a Q&A, which I think deals with really the application of Statement 84.
Yeah, I am raising the issue, Dave, because of the similarity of allowing employer contributions, which wasn't there to begin with, and what's going on with 57 World. It's something we need to, I think, do a little digging into, because, again, I think the benign neglect might be prevailing there.
Okay. Yeah. I think the application of 84 may identify a number of those situations.
Yeah. Not trying to bundle it with this project.
Yeah.
If we go with this project.
Sure.
But also saying we can't. I don't think we should just sit silent.
Yeah.
Mm-hmm.
Any other questions or comments from board members?
Mr. Chairman, if there aren't any comments, I just, if it's all right with you, I'd like to just give a kind of a little sneak preview of the technical plan, if I could.
Yes, please.
As we mentioned, we're going to follow this discussion up with a prospectus for a potential project. In addition to that, a couple of issues that we discussed with GASB. One is the secured overnight financing rate, SOFR. We have a potential practice issue project prospectus that is being finalized for your consideration. So that's one additional practice issue project. And also, as we mentioned at GASB, we've had a request regarding the effective date of Statement 87. In the words of our old friend Bert Edwards, retired partner from Arthur Anderson, if you're going to take a bath, fill the tub. And so we're looking at an omnibus project, and we kind of asked staff to pull together a list of issues that have been nagging for, if you're going to issue a standard, are there some things that we could potentially clean up in the literature that would be quick hits, something that that people either will go thumbs up or thumbs down to rather quickly without a significant amount of research, where we have conflicting pieces of literature in our existing standards. So you will be seeing a project prospectus related to an omnibus in addition to the other two items.
Thanks, Dave. Any other thoughts or words of wisdom? Not hearing any. I guess that completes our discussion for today. Thanks, everyone. Appreciate it.
Thank you, sir.
Meeting's adjourned, and have a great one.